Hello, everybody, and welcome to our online workshop, How to Give Yourself Plan Security for the Rest of 2020. My name is Andreas, and I am the Client Services Coordinator for the Greene Estate, Probate, and Elder Law Firm. We are very happy to be back hosting another presentation for you guys, and we would like to thank all of you for taking the time out of your day to be with us and join us today. Now, before I introduce today's presenter, I wanted to briefly go over how the webinar is going to work. So we're currently streaming through two platforms, which are Zoom and Facebook Live. Now, if you're on either of these platforms, we encourage you to use the chat box and submit either a comment or a question that you have pertaining to the presentation or estate planning in general. At the end of the presentation, we'll be going over the comments and questions that you left, and we're expecting the presentation to go for about an hour. And after the presentation, the questions will be about 10 extra minutes because we don't want to take too much of your time on a Friday. I know it's early, at least on the West Coast for us, it's 10 a.m. And if you actually get the chance, you could type in where you're tuning in from. I know we have some East Coasters, we have some Alabama folks, and definitely people out here on the West Coast. So without further ado, I would like to introduce today's presenter. He is the founder, attorney, and CPA of the Greene Estate, Probate, and Elder Law Firm, Jay Greene. Jay, how are you today?
Good, good. Thanks so much for that introduction, Andreas. We're very glad to have everybody join us to take some time out of your day so that we could talk about estate planning and some of the things happening in 2020 and how that impacts you. So what I want to do is go ahead and pull up our presentation so that we can get started and stay on schedule. So what we're talking about today is how to give yourself plan security for the rest of 2020. It's been a hectic year, both in the world and for a lot of people individually. There's been a lot going on with the coronavirus. There's been protests, the things kind of leading up to the protest. There's been a lot of, there's election stuff going on. And for a lot of people, that's created a lot of financial issues for them personally. It's created a lot of emotional issues and how they're dealing with everything. And all of that impacts our estate plan. And what we want to do is make sure kind of no matter whatever's happening to us financially, whether our assets go up in the future, whether they go down, for us emotionally, just making sure like we add an extra layer of security for ourselves this year. So that's what we're trying to do with this presentation. So I want to tell you just kind of the agenda of what we're going to do today. I want to tell you a little bit about me. We want to make sure that we're identifying whatever you came here today to learn about. You took time out of your day so that you could come and learn a little bit about estate planning, learn about protecting yourself in this period of uncertainty. We want to make sure you get those questions answered. What we're also going to do is discover 3 steps to help you protect you and your loved ones. So we're going to talk about what you can do today to make sure that you're protected no matter what happens. And then we're going to have an evaluation at the end. We're going to send you that information. Andres will give it to you. And we're going to close and we're going to help you work to create your action plan to make sure that you and your loved ones are protected. So a little bit more about me. I'm Jay Greene. I'm the attorney and CPA. I am the founder of the Greene Estate, Probate, and Elder Law Firm. You can find us online at assetprotectionbayarea.com. Our vision statement is to be an educational firm so that we want to help others achieve their goals and protect themselves and know that they have security for them and their loved ones, for their family. I am from the South, if you can't tell. One of the things that's important to me and kind of why I do this is I saw in my own family, my parents having to deal with my grandparents and my grandparents not having planning in place. The tensions that created between family members because of dealing with estate issues, dealing with not putting plans in place around the end of life, and how that put a lot of strain on my parents during their lifetime. So what I want to do is kind of dedicating myself so that for other families, they don't have these type of issues. So one of the things we want to do is make sure that your questions get answered. The way we're doing this online is if you have questions, you can submit them to Andreas. He's on the chat bot, so you can send your questions directly to him. You can send them out to the group if you like, and we're going to make sure we answer all those questions. We'll answer those questions at the end of the presentation just to make sure you're getting the information you want and need. So goals of this workshop. What we want to do is identify if your current plans meet your goals. If so, then you're all set. But what we want to do also is understand what it takes to protect you and your stuff. We want to make sure that you can leave and you can anchor back to the stories we talk about in the workshop, and then you'll be able to tie those back into your life and making sure you're protected. We want to show you how you can get what's missing so that you'll be all set and you, your loved ones, all your family members are protected. So we're going to talk about the 3 steps to plan and protect you. You need to know what the rules are so you know what you're planning against. You need to know what the government has in place and what they allow you to structure around. You also need to know who your predators are. When we're doing all this planning, why are we doing this planning? How are we going to use this planning to protect you so that these horror stories from estate planning don't happen in your situation? And then we're going to know what your options are. We always give people an education, and then we tell them how they can protect themselves. And then you can decide which option works best for you. So number 1 is you need to know the rules. So the government has rules when you're alive and well, and they have rules after your death. And if you do not put plans in place, those are going to be the rules that impact you. There's also different levels of planning you can do. Maybe you decide you have a minimal plan. You create a power of attorney. That's what handles your financial affairs. So that's going to do your legal affairs and your financial accounts. You could have a healthcare directive. That's what's going to be a healthcare proxy so that somebody could make medical decisions for you, and a living will that's a set of instructions about what you want to have happen. If you decide not to do anything at all and have no planning, what happens is you're given the government control. So that would require a guardianship. That's going to require doctors signing off that you've lost capacity. It's going to require court hearings almost for any transaction that needs to occur for you. So what we want to make sure is we don't put ourselves in a situation where we end up with the government being in control of us. We want to make sure that we stay in control no matter what's happening. So the government rules after death is if you create a last will and testament, that would be the minimal level of planning. You'll get to name somebody to be in control, an executor. You get to determine who gets your stuff. That's going to be called a beneficiary when you have a will or a trust. But at death, it still requires probate, which is a government process, and you're subjecting yourself to those government timelines and also the government fees. So what if you don't have any of this? You don't have any planning. The government's still going to name somebody to be in control for you. That's going to be an administrator. For many people, this won't even be somebody you know or connected to. It'll be somebody that the court just appoints, probably another attorney like me. So it can get very expensive. So who gets your stuff? That's going to be your heirs. So your heirs are the people that are legally entitled to your stuff when you die. So who has heirs now? Nobody, because you're not dead yet. So we don't know who your heirs are until you die. So we don't know if we have minor heirs. We don't know if we have disabled heirs, because a lot can change between today and the day that we pass away. So that's not the best way to protect our heirs, is just by letting the state and government have control. At death, it's also a lot more complicated because the probate process is more extensive when you don't have any type of estate planning. And it's more expensive because of the time involved with it. One thing some people think is when they have a will, they don't have to go through probate. So a will is allowing you to put your own structure in place, and that's going to control anything you own in your own individual name. But all of those items have to go through probate. So you're still subjecting yourself and your estate to these more expensive probate fees because we have a will and we're going through probate. So probate is estate administration. What happens is a will gets validated, the debts get paid, and your assets are distributed to your will. It's the only way to change legal title to the assets that's in your name directly. So what happens is it's a government process. So it can, anytime the government gets involved, it can get a little complicated. Some of the problems with going through probate is a court is interpreting your will, and so you having control on it. So if a judge thinks there's ambiguities in what you wrote, it may not get interpreted the way you want it to. It's also easy to contest a will. If you're an heir and just don't respond back, that may trigger hearings that have to happen in that probate proceeding for it to move forward to be able to close the estate. It's also expensive. In California, the probate fees are 3 to 5% of the estate. So for every 100,000, you're looking at about 3 to 5,000 in probate fees. That's based off the gross value of the estate. So if you have $1 million house and you have an $800,000 or $900,000 mortgage, it's still based off that $1 million value. So you'd be looking at like 30 or 50,000 in probate fees. So what we want to do is make sure we avoid those fees. Also, from a time perspective, it takes a while. We have to give notice to creditors before anything can be paid out. So that notice process can be anywhere 4 to 6 months. And then we have to have court hearings so that we can get through that probate process and actually make the distributions. You're probably looking at about 9 months to 2 years. The average is a little bit over a year. Now, because courts are backlogged from COVID and being shut down earlier in the year, those time periods would actually be extended further. During this period, your heirs really have no control over the assets. They're kind of subject to the court's discretion in what they're doing with the assets. So what we want to do is make sure that we have clear instructions for our family and they have control right away. It's also a public process, so we have to give notice, so there's no privacy. So that could potentially trigger people to go look for our heirs if they know they're receiving a lot of money for, investment devices and things like that. We want to protect our heirs as much as possible. So going through probate may not be the best thing for you and your loved ones. So in my office, one of the things we talk about is some of the distinction between having documents versus having planning. So you can have a power of attorney, and they're pretty easy to get, but for a lot of people, those are just going to be documents. It's not going to be a plan of what you want to have happen. If I have a blank check and I give it to somebody, what can they get? They can get everything that's in my bank account. But if I give somebody my power of attorney, what can they get? They can get everything I have. So what we want to make sure is we're not giving somebody that super blank check. We want to make sure that there's restrictions and it's tied to our estate plan so that when people are using our power of attorney, if we become disabled, that it's actually going to be tied in to what we wanted to have happen with our estate. We also want to make sure that there's full authority with that set of instructions. In the event that we need asset protection planning for long-term care costs, our power of attorney has to have the authority to do that type of planning, and that's got to be within our documents. And that's just not something that's available if you're going and getting forms offline. It doesn't have the level of planning to plan for you if something tragic happens and your capacity changes. So what we want to do is make sure we have a broad power of attorney that is restrictive and tied back to what we want, but it's going to be broad enough for us to do the things we actually need to do when we can't do them for ourselves, which is why we're creating the power of attorney, is to make sure our life and our needs are getting met by our trusted advisors when we don't have the capacity to do it ourselves. The other thing we want to do is make sure somebody can make medical decisions for us. And maybe we want different people to make financial and medical decisions. So we can name somebody who's our healthcare proxy. So they're going to determine what happens to us if we're terminal, comatose, vegetative. So what we want to do is make sure that we pick people we trust in that role. But then if we just give them that level of authority, we're kind of giving them a God power over us to determine whether we live or die, without us having control of what we actually wanted. So that's where we put in a living will. We want to make sure that we have control even when we're not around to make those decisions. We want to determine what type of care we want in different medical situations. That's why we do a living will that's a set of instructions to our healthcare proxy and our medical providers about the types of medical care we want in different situations. We want to make sure too that potentially we give that healthcare proxy a second chance to look at the decisions we made and determine, do we want to give them the ability to decide something else that day when they're in the doctor's office? So that's going to be that second crack at the apple, because maybe on that day at the doctor's office, they may have some different directions than we have on the day we signed this in the law firm. So we pick a healthcare proxy we trust, we give them a set of instructions what we want, and then we can determine if we give them the authority to do something different than those initial instructions we gave them. Also, we want to list out about organ donation. We want to make sure that they have HIPAA access to our medical records. We also might want to have a personal care plan. So in those situations where we're not terminal, comatose, vegetative, if you're healthy as an ox, but think you're George Washington, what do we do with you on those days? How do you live on those days? What plans are we putting in place to make sure you're protected? We want to make sure that we're putting plans in place that we're always protected, even if we're not terminal, comatose, or vegetative, but we still can't make decisions for ourselves. Is there a clear set of instructions about what we want and what we want our lives to be? Also, having a last will and testament. It's a document. It's good to get you through probate process and have guidance about what you want in the probate process. But what we want to do is make sure we're not just creating documents that make us feel better today. We want to make sure that we have goals of what we're trying to achieve and what we're trying to achieve in our estate plan. We want to make sure that we're putting plans in place so that we achieve our goals. So when we're talking about the 3 steps, one of the first things is knowing your predators. Where are places and opportunities for you to lose control of yourself and lose control of your assets and lose control of what's happening to your loved ones? So your predators is the government. The government's always a little bit of a predator because there's always taxes, there's always a government process to go through that can be confusing and stressful for the family. Long-term care costs. When we start thinking about elder care and what's going on with that, how are we going to pay for these long-term care costs? And then we have predators of people who don't intend to be predators. Sometimes our family can be a predator from what we're building in our state. And then lawsuits. You know, we live in the US. Do people sue each other? Of course they do. There's a ton of lawsuits. So how do we protect ourselves from these predators? So how is the government predatory? So one is court proceedings. If we become disabled and we have no plans in place, what about going through a guardianship and having the court decide everything that happens to you? How about the court deciding some stranger being in control of what's going on with you and your life and your placement? That's not something we want to subject ourselves to. We can put documents in place so that we're not going to be subjective, and we're naming who we trust to be in those roles. And so instead of the government just picking somebody random to do it. Also, when we're talking about probate is just a long, complicated process to go through in the court. There's so many notices and the time involved with it, and the particulars of filling out certain forms. It can just get time consuming and stressful for those involved. So there's simpler ways than having to go through court with either a guardianship or a probate to administer your estate when you're not able to. And then taxes are always predatory. So we're thinking about estate taxes. If we're over the limits are very high now. They're about 11 million for a single person, about 22 million for a couple. They're set to go back in 2025 to right around 6 and 12 for a couple. But so there's some people, especially in San Francisco, that may be above those limits. So we need to do estate tax planning. But a lot of people are going to fall below those limits. For everybody falling below those limits, it creates opportunities because now you can do different types of planning to protect your assets long term. So then we're thinking about long-term care costs. All of us want to stay in control. We want to stay independent for as long as possible. So we want to stay at home. But whenever we start having medical conditions, it can get very difficult for us to stay at home. Those costs probably are going to be $3,000 to $4,000 a month. If you start needing around-the-clock care, it can go way upwards of $10,000. For assisted living, you're probably looking at very base level entry at $3,500. You're more in the $7,000 range, $10,000 range. And then for skilled care, which would be nursing homes, you're looking $7,000 to $15,000 a month. As you can see, it's going to get very expensive trying to pay for that. So when we start talking about long-term care and we're talking about who's going to pay for it, either you're going to pay for it, the government's going to pay for it, or you're going to have a long-term care insurance that's going to pay for it. And in what order do you think the government's going to pay for it? They're going to pay for it last. So that means if we have long-term care insurance, we'll be able to use that first to pay for some of those costs. Some people have older policies and the benefits may not be enough on it to actually cover your care. Then you have to spend your assets down. So if we're looking at Medicaid or Medi-Cal, you have to spend down to $2,000. So what we're looking at is trying to make sure that we have plans in place while we're healthy about how we're going to pay those care costs, so we're not in a situation where we run out of money. So that's where we look at Medicaid, we look at Medi-Cal. If you're a wartime veteran, we can look at different veterans benefits available. A lot of people are concerned about some of these benefits because they've heard they're going to come and take your home, that you have to give away everything you have to protect it, that you have to give it away and then wait 5 years so that you can qualify. Those rules are, some of those are general guidelines, but that may not be the fact patterns in your situation. All of these government programs, they're complex sets of rules, and they have a lot of exceptions. So that's why you need to be working with a qualified elder law attorney so that you're doing planning that's going to work. So when you need these types of benefits, you have plans in place that's going to meet them. Then we have some unanticipated predators. These are going to be unintentional predators. It's going to be your family. How can your family be a predator? Because they don't want to be a predator. They don't set out to be a predator. A lot of times our spouse can be a predator. The spouse we have right now with blended families. If a spouse remarries, we want to make sure that everything doesn't end up with their new spouse and the new spouse's kids. We want to make sure that our kids, our loved ones are protected. Also, if our spouse needs long-term care, that could start eating through our assets. It can leave us with not enough assets to live off of. So what we want to do is make sure that we got planning in place so we're not going to deplete everything we have. Also, our children, our beneficiaries can become predators. They do that by, maybe they have a spendthrift problem, and if you give them a dime, they spend a quarter. So what we want to do is not leave them all the money in such a way that they run out of the money that we're leaving that we wanted to protect them with. Also, maybe they have a bankruptcy. We don't always know everybody's financial situation. So maybe they have financial troubles going on, and if we leave them that money, it's going to be ate up by these creditors, if they file for bankruptcy. So we can put strategies in place so that our loved ones are protected no matter what happens, that there's always this extra bucket of money that's protected for them. Maybe they have an addiction issue. If somebody has an addiction issue, one of the quickest ways to kill them is to give them a lot of money. So what we want to do is if somebody does have an addiction issue, is we want to make sure that we help them and we protect them like we've always been planning on doing, but that this money is structured in such a way they're not going to be able to harm themselves. What happens if somebody's disabled already, or they become disabled and they're getting some of the government benefits, Social Security, housing benefits? We don't want them to lose that money. So we can put planning in our own existing plans now to make sure they're protected. We can set plans up for them if they need it to make sure they don't lose their benefits. What we need is, because, with our heirs, as we were talking, we don't know what's going to be their condition on the day they died. Did we die in a car wreck and they were permanently injured in that car wreck? How are we going to make sure they're protected and they have access to benefits and this money that we're leaving them? Also, we want to think about divorce. So we want to make sure that if our loved ones get divorced, the money we're leaving them is not going to be subject to those divorce proceedings. So we can put plans in place so that no matter what happens to them, they will always be protected and this money's going to always be available to them. Also, if the parents are trying to get financial aid, we don't want the grandparents to leave the parents a lot of money, and then that's going to impact their ability to get financial aid for the grandkids. And then we're thinking about lawsuits. Lawsuits against you. How do you protect yourself if you're a business owner? How do you protect yourself if you have rental property? How can I make sure that if I get sued on one rental property, I'm not going to lose all of them? How do I make sure if I get sued for my dental practice that I'm not also losing the building that it's in, that I'm not losing my personal home? How do we segregate these things and add layers of protection? We also can make sure we give that same type of protection to our beneficiaries, so that if our beneficiaries inherit from us this money we've worked our whole lives and that we want to give them, how are we putting a plan in place that we know they're protected no matter what? To kind of illustrate what happens with a spouse is if you own stuff jointly, you probably think that's a good way to own it because you're bypassing probate. So you're going to avoid those probate costs. But if you're married with a spouse and you have kids, so in this situation, we're talking about Bob and Sue being married. Sue unfortunately passed away early. So then they owned it jointly. So the house went straight to Bob. And then Bob remarries. So you remarry Sylvia. And then, 5-10 years down the road, Bob passes away. Bob and Sue's kids were close with Sylvia, but never were quite in the family. So what ended up happening is, because Bob and Sue owned the house jointly, Bob and Sylvia ended up owning the house jointly down the road. So then when Bob passed away, the entire house ended up with Sylvia. So since Sylvia wasn't close to Bob and Sue's kids, what happened to the house when Bob passed away and Sylvia passed away? Everything went to Sylvia's kids. So Bob and Sue's kids got disinherited because of the type of planning Bob and Sue decided to have. So what we have is a better way to avoid probate court without running the risk of disinheriting your family. So the next thing we want to do is make sure you know your options. So to know your options, we kind of have to talk about estate planning. Why are we even doing estate planning? What we're doing is we're making sure that we stay in control. When we are alive and we are healthy, we want to be in control of what's happening to us. When our health situation changes, we still want to be in control of what's happening to us. We want to determine who gets to benefit from our stuff. So with our stuff, we want to make sure if we're still living and we just can't make decisions for ourselves, we want to make sure our stuff is still getting used for us. We want to make sure that we still have access to what we need and that there's a clear set of instructions about what we want. We want to determine who else benefits too. Are there people that benefit now that we want to make sure benefit when we're disabled? And then who's going to benefit when we pass away? What happens if our spouse becomes incapacitated, remarries, when our spouse passes away? We want clear sets of instructions because we're not trying to control what happens to the spouse's half, but we want to make sure that our half gets to the people we wanted it to. We want to make sure it benefits our loved ones in the structure that we provided when we did our estate plan. We're also, what happens with our children? If they become divorced, if they become disabled, how are we going to make sure they're protected? So the definition of estate planning is, I want to control my property while I'm alive and well. I want to plan for me and my children and my loved ones if I become disabled. And I want to give what I have to whom I want, when I want, the way I want. And we want to do all of that without becoming a burden by causing unnecessary cost or delay. We want it to be simple on us while we're living. We want it to be simple on us when we're disabled. We want it to be simple on our loved ones when we're disabled. And when we pass away, we want it to be simple for our loved ones so that they can settle our estate quickly and without a lot of confusion. So what people do when they come to my office, they want to stay in control. They want to not be a burden to their loved ones, and they want a plan that's simple. So what you get when you come in my office working with us is you're going to know the difference between just having a set of documents and doing actual planning that's achieving your goal. You're going to understand all the cost involved, both with creating a plan and the cost on the back. And what we're going to do in my office is we're going to minimize all of those costs. You're going to know your options and you're going to be able to choose the plan that's right for you and your loved ones. So we don't have cookie cutter plans in my office. They're very personalized so that you are able to make decisions that reflect the way you live today and the way you want things to happen after you become disabled or you've passed away. So, here's your options. You can use the government's rules. You can do no planning. That's going to mean that the government's in control of what's happening to you. That's the same whether you have a disability and you can't make decisions for yourself, or you pass away, the court's deciding what's happening to you. The government has wrote a set of instructions about what's going to happen to you. A lot of times for a lot of people, it's not simple. It causes a lot of stress for your family members, and it may not reflect your wishes because you may not be close to some of your family that they want included in your plan. You could decide to do minimal planning. We could do some base instructions, some base power of attorney, a base healthcare proxy, so that there is something in place if you become disabled. If you pass away with this minimal planning, you can decide who's in control for you instead of the court appointing some random person, but it's still subject to court supervision. So you're still got the government involved, so it's still a little bit more cumbersome. You can also decide to create a probate avoidance plan. That's going to be still just base level planning if you become disabled, and then base level protections if you pass away. The good part with a probate avoidance plan is we're not subjecting yourself to government control. At my office, we offer all types of levels of planning, so we offer all of these base plans. What we also offer, though, is the opportunity for you to create your own custom rule book. So how would you go about creating your own custom rule book? Well, it's you. It's what you want. So it's making sure that it's your voice, and you're making sure that it actually works now. Because we're creating a detailed plan when you come through my office, we're designing something that matches you and your needs. And we're going to create something that works. It's your voice and a trust. So it's not the government telling you what's happening to you. It's not them dictating when stuff goes to your heirs. It's you setting up a structure in place for that. That's what a trust can do for you. It integrates the rules you have with your life and your stuff now into your estate plan. So the level of control you have in your life now, it makes sure that level of control is there if you become disabled or you pass away. It maintains your rules no matter what's happening with your life or if the laws change. They're very customizable and they're easy to update. So without all three of these, your rules normally aren't going to work. They're not going to be effective. So what we want to do is make sure we're putting a plan together that works. So what happens a lot of times with attorneys is you'll go in town, there'll be a lot of trust mills, and they're just throwing names and blanks on forms. So some of these firms, they have very good marketing, but sometimes they don't have good lawyering. So typical trust, they're just documents. They're not your rule book. They're not your set of instructions about what you're wanting to have happen, guided by your life and your life experiences and what you want. They're subject to control by doctors. We're still waiting for sign-offs from people. It does give you probate avoidance, but only if it's integrated. A lot of people are not actually following through and getting the plans funded and making sure that it's fully integrated with your life. So that's one of the things we do in my office is we make sure we're creating plans that's going to work for you. And then it's outright distribution at death. So when we're talking about earlier about protecting assets for your beneficiaries, we can put structures in place to make sure your beneficiaries do not get taken advantage of by what you leave them. You can't do that with a lot of the form planning that a lot of law firms offer. It doesn't give that customizable level of access. So what happens is we create personal options. You'll walk into a lot of attorneys' offices and they're going to say, we do that. So I've heard people too say that they're getting benefits set up with a base plan for Medicaid planning. There's really only a few companies in the nation that are offering this type of training and estate planning software that offers this type of planning. So a lot of attorneys, because they don't understand trust completely, they're not actually putting you in plans in place that make sure that if your parents need government benefits, you're not kicking them off, making sure that the heirs are not going to lose their benefits if they all of a sudden go on Social Security. So what we want to do is make sure that we have more comprehensive, more personalized, enhanced planning. We wanted to have personalized disability rules and instructions so that when we are disabled, there's no confusion about what's happening to us and our stuff. We want to make sure that we're giving asset protection planning to our beneficiaries. Now, the IRS has determined with retirement accounts, those used to be asset protected. Now, when you leave them to your beneficiaries, they're no longer asset protected. So what we can do is create structures so that they're asset protected and incorporate that into your trust. With the Secure Act, which is a new act, what we're doing is the retirement stretch provisions have changed, and what we can give to spouses and the amount of time is subject to 10 years for a lot of our beneficiaries. A lot of people that have prior trust documents prior to this year, you've actually got retirement account provisions now that are a little outdated because of the Secure Act. So what you want to do is make sure that your trust provisions, if you have retirement accounts in there, are actually updated, planning for these asset protection strategies and making sure it's in compliance with the Secure Act. So that's what we can do in these more personalized plans. Also, when we give our spouse money and we might be worried about them needing long-term care in the future, we don't necessarily want to give it all to them for them to lose right away to a nursing home. So if we give our spouse $1, what can they do with that dollar? They can do anything they want. But what if I take that dollar and put it in this asset protected box for them? Because they can't get at it directly within this box because we have it set up with a co-trustee that they pick, then it's asset protected. So then if they have a creditor from a lawsuit or a nursing home try to get that money, they can't get it because they can't get the money directly. So we're protecting it so they don't lose it to long-term care cost. The same thing for our children if we're talking about beneficiary planning. Tom and Sue are brother and sister. They moved down to the coast. They're living by the beach. Sue married a biker, Johnny. Johnny runs off and meets the barmaid, Bambi. And now Sue's inherited this money. Sue's bought a condo at the beach. Sue's worried now because Johnny, the biker, is talking about leaving her for the barmaid, and he wants to get the house. What's going to happen now is that when we gave the house to Sue, she did not own it directly. She owned it in this asset protection trust. So now her husband is not going to be able to sue her in the divorce proceeding and try to take that house because she never had it. So what we did is we protected that inheritance so that it's protected from divorce, it's protected from other creditors, lawsuits. So what we're leaving for our family members is always going to be available for them. So there's misconceptions people have about trust. People think you have to have a lot of money or you have to have a lot of assets to have a trust. People think I'm not old yet. I don't need a trust yet because I'll just wait till I'm older. I don't need a trust because I don't have children. I don't have people depending on me, so I don't need a trust. But a trust is a document that you put in place for you during your life and your lifetime to make sure that you're okay. It's not just a death document. It's a disability document. It allows you to put plans in place about your voice and your rule book, how you're going to be treated, and then how you want your money used for you and your loved ones in the future. So having a rule book is the first step. Then you need to integrate it. So when we're talking about a trust, it's kind of convenient if we kind of think about it being a little red wagon we pull around. So if you're walking through life and you have your house as a box, you have your stock and investment accounts as a box, you have your bank accounts, brokerage accounts as a box, if you die or become disabled, what happens to those? Well, they're going to hit the ground if you're just holding them. So if you're disabled, if you have a power of attorney, that person can come and pick them up. If you have a will, then an executor can come and pick them up after a court is giving them that authority. But those boxes still hit the ground and they're not necessarily protected. There's transitions that has to happen there. We may be waiting for doctors to sign off to say that somebody needs to come pick those up. So the alternative to that is having a trust. So the trust is your little red wagon. So the trust is like the little red wagons you'd pull around as a kid. Instead of holding these boxes in your hand, you can take those boxes and you can set them in the little red wagon. When you set those boxes in the little red wagon, if something happens and you die or become disabled, what happens to those boxes? They don't hit the ground. They stay in that red wagon. So they're safe. They're exactly in the same spot they were before. The only thing that hits the ground is the handle, which is your set of instructions that you created within the trust about how the money's managed, how it gets used, who it benefits. And the person that's going to come and pick that handle up is the successor trustee that you picked. They're going to come and grab that handle, and that's going to be a set of instructions about what you wanted to have happen. So it makes sure that those assets are always protected and always available for you because they're in the exact same spot and condition they were before you became disabled or before you passed away. So it just gives a lot of flexibility and a lot of security to you and your loved ones, and it's not complicated. There's not some new additional process to go through. It's just switching out the successor trustee. But you're saying, what if I have joint accounts? What if I have payable on death accounts, beneficiary designations? Well, you avoided probate, but they're not integrated. They're not part of your plan. You can subject yourself to losing it if a spouse remarries later for your kids. It's also it may not have the levels of protection you want because people's getting stuff in their own individual names. So you're not protecting them from divorces. You're not protecting them from bankruptcies. You're not protecting them from their own creditor issues. So another option is asset protection trust for yourself. The difference between earlier is we're protecting your beneficiaries. With this trust, we can protect you. If we're needing to look at government benefits like Medicaid, Medi-Cal, wartime veteran benefits, it starts the clock for those transfers. It preserves your money for you, your children, those you love. And one of the biggest things is you stay in control with these trusts. You're not gifting it to other people and losing control. Some of the disadvantages is that you do have to give up the direct access to what you want to protect. So we have structures in place where you name co-trustees, lifetime principal beneficiaries that you can change. It's a little harder to undo than revocable living trust, but there's different mechanisms, trapdoor mechanisms for you to be able to get your money back. It protects you from divorces. It protects you from predators and creditors. It protects you from nursing home costs, and it starts the benefit clock. It protects you from family indiscretions to make sure that people's not go lose the money that you worked so hard to accumulate during your life. So by doing these types of planning, what we can do is avoiding the cost of doing nothing. We avoid those high probate costs of 5 to 7% of the gross estate, the delay that can be upwards of 9 months, the public filing of assets. It keeps everything private, and we don't have to notify all the heirs. the spouse blows or loses the heir's inheritance, we want to make sure that if we have children, other loved ones, that we don't leave it to the spouse and then our loved ones don't get anything. We had the problem that maybe our heirs have some issues, so when we leave it to them, they end up losing it. So we're putting structures in place so that they're protected. And we can save ourselves from the expense of high nursing home cost. So not maintaining your plan. Once you have a plan, it's not that you never look at it again. Your plans need to be reviewed. They need to be updated. You're going to have changes in your family circumstances. People are born, people die, your money goes up, your money goes down. That may change what you want to do with your planning. So you need to review that. You may have trustee, executor, agent changes. Maybe you have a different relationship with the people you chose or your beneficiaries. So you might want to update those over time. And like we were talking about with the Secure Act, when we're looking at a Medi-Cal, Medicaid planning, when there's changes to those laws, we need to make sure that those are incorporated into our plans. So how do you protect your stuff? It's 3 easy steps. All you need to do is act. You need to assess your needs. You need to create what's missing in your plan, what you don't have today. And then you need to tie your plan in with your life. You need to make sure it's integrated and it works so that it is seamless when something happens to you. The step that you would want to take after doing this is you would want to book your free vision meeting. Anytime somebody comes to a workshop, I give them the opportunity to have a vision meeting. These are online now with COVID, but it makes sure that you're protected. You're kind of going through some of these stories we talked about today, some of the condo story, the dollar story, and we will tie those into your life. You'll let me know about you, your loved one, your family, and what we're trying to achieve for you. So what we're going to do is you can book your free vision meeting. Andres is going to put a link at the end of this meeting and you can schedule. That's going to let you know what type of planning you might need for your situation. If you choose to move forward at the end of that vision meeting, the next step is we're going to have a design process. It's coordinated by Andreas. This normally lasts a couple of weeks. It allows us to collect the relevant information to create the customized plan that you decided you wanted to move forward with. So what we're going to do is give you some peace and security by knowing that your estate plan's accomplished. Once we get through this design process, then we're going to have a signing meeting. The signing meetings are handled with social distancing requirements. You know, we're doing the mask, hand sanitizers, and distance between us if we're doing stuff in person. There is the ability to do a lot of document signing through online notarization. So we have both options available with our firm right now. And then fourthly, when we're talking about earlier, we want to keep our plans up to date and make sure that as our unique needs change and what's going on with us and our loved ones, our family changes, that we are keeping our plans up to date. We have an optional maintenance program. It's not required. You can determine you want to do it or not do it. If you want to do the optional maintenance program, it's there, and you can determine that as you're going through the signing process. So as I said, Andres has put a link in so that you can book an appointment on the Square app. So it's a free consultation. It's available for the next 30 days so we can find out what is best for your personal situation, and there's no obligation. We want to be a resource to you, your loved ones, your friends and family. If you think there's people you know that need to do their estate planning or revisit their estate planning, maybe because of COVID, maybe they might want to change their healthcare proxy and the requirements in it, or the Secure Act. They have retirement assets going through their estate plan, and we need to make sure that the new Secure Act provisions are in their trust documents. We need to put those in place. So definitely share with the friends and family. Let us know. The way you would do that is we have an evaluation to let us know how we did today. What we want to do is make sure that this is a good use of your time. You found the information to be helpful. If you have questions, we want to know what interests you. If you have questions, you can also write them there. And then if you have friends or family that you think might be interested, then you can let us know in that too. It's a link too that Andres is putting in the chat box. So if you go in the chat box, there'll be a link for the evaluation. There's also a link if you want to have a meeting. Definitely, I know people get busy, and we're glad you took the time out, an hour, to come and learn about estate planning, but you can go ahead and open that evaluation up and do it so that we know how we did today. It'll be in that chat box, and we can go over some questions why you complete your evaluation.
Great presentation, Jay.
Thanks. Thank you.
So we have one in the chat box, and it says, what are the fees past the initial consultation?
So the initial consultation is free. So for the initial consultation, you just come in and we go over your family, your situation, and what you want. That we're going to tie in to the stories we talked about in the workshop to kind of help you pick the different types of plans and kind of decide what's best for you and your situation. And then we present the plans for you. We have 3 different options for most people, and they would decide between those 3 options. Those plans range in cost from $1,000 up to $10,000. And it's really not based off of the type of assets you have or the type of like the money you have in the bank or anything specific about your family. It's really up to you. It's you understanding, getting an education through attending this workshop and then sitting in the vision meeting about what your risks are, and then you determining what plan works best for you. A lot of the trust planning is right around, it starts at $2,500 and it goes up from there. We have different levels because we have different protections for the beneficiaries.
All right, the next question we had submitted was, how do you decide if a trust is more useful than our separate wills?
Well, it's a lot of that kind of anchors back to what we've been talking about today. Is a trust offers so much more flexibility than a will, because a will still has to go through probate. So you're subjecting yourself to probate proceedings. Also, with a trust, you're able to put your own set of instructions in, what you want to have happen. So it's not the government being in control of you, it's you maintaining control even when you become disabled or pass away, is you and your wishes happening. So a trust is always going to be the easier route to go to maintain control. In California, if you have a will, you still have to pay those very expensive probate fees. So in California, it makes a lot more sense to have a trust because probate's so expensive.
All right, next question. What is the difference between financial power of attorney and durable power of attorney?
So a durable power of attorney continues upon your disability. So they have some powers of attorney. If they're not durable, they could end when you become disabled. So that's the time you actually want it. So when we're looking at doing estate planning, we always want to have a durable power of attorney because it carries beyond our period of disability. So when we're doing that, we want to pick an agent that we trust, but we want to make sure it's tied back so they have complete authority. So if they need to do asset protection planning, they can for us, but we want it restricted to our current estate plan.
All right, we got another question, and it says, is it better to hold real estate assets in an LLC or a trust?
Well, LLCs, the difference between a trust and an LLC, an LLC is a public document. It requires public filings. It requires annual fees. So a trust is a private document, so it's not submitted anywhere. There's not a list of the trustees and beneficiaries maintained by the state for anybody to go check. And also, you're not having to pay annual maintenance fees on the trust to the state. You're not paying like an annual filing fee for the trust to the state. So you're saving in these government costs. Also, the government has a lot of rules of how LLC works and the structure for it. In a trust, you're able to structure those yourself. So you have more control in a trust.
All right, the next question is, as a single person, what expenses do I plan for so I do not leave expenses behind? And what are the costs? Cremation and life insurance.
So what we definitely want to do is do a comprehensive plan and kind of look at everything you have going on. I, of course, don't sell everything involved with end of life issues, but because I am in these professional relationships, I definitely have good professional relationships when we're talking about cremation. It's very important to get those things paid if you have some extra money, just so people don't have that burden when you pass away. Life insurance is very good. Some of the people asked about life insurance. I'll send a private message and give you some connections of people you could talk to about life insurance. It's very important to have those things because we want to make sure if somebody's depending on us for money, they have those resources later on in the future. When we're looking at estate planning and avoiding some of those costs, that's going to be some of the stuff we talked about today. The probate, it's expensive. It's 3 to 5% off the gross value. We want to make sure we're not subjecting our heirs to that financial cost, but also the personal, the emotional costs, the family stress of having to go through court proceedings when they have other stuff going on in their life and taking them away from that. So it's not just the monetary cost of doing stuff, it's the emotional cost and stress when things are not going right. So if we put good comprehensive planning in place right now, we can keep our beneficiaries from having that type of stress.
All right, so far that's all the questions. In case anyone has any more questions or comments, we'll stay leaving the chat box open for another couple minutes. Other than that, though, very, very pleased that everyone showed up today. I'm very pleased with the presentation as well. Great job, Jay.
Thank you, thank you. And I want to remind everybody again about just the chat feature. The evaluations are very important to us because that's how we know what we did today was useful for you and it's answering your questions. So definitely before everybody signs off, if you could just go and do the evaluations quick so we know how we did. And then on the appointments, be sure when you're already in this mindset and you're thinking about estate planning that you go ahead and set up your appointment with us so that you can set them off. I think they could even go a month off. So if you try to get it within the next 30 days, if you're not free in the next week or two, you can go ahead and get it on the calendar so you know it's booked and you're moving forward with your estate plans.
Yep, and for the consultations, you could choose either a phone call or a video call through Zoom. And while you're booking the appointment, you could type in notes or any concerns you have prior so that we could be more aware of what you're looking for, and then we could plan the meeting according.
All right, that sounds great. I appreciate all your help, Andres.
Yeah, pleasure.